Hello, this is U.S. Immigration Attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. Go ahead and put your questions in the comments now so that I can answer your questions. What I'm going to cover briefly, and then we can go into your questions, is this: get protection from removal. The time is now. The laws are still in place that can allow you to get protection from deportation. And I want to talk to you about some of those options because they do exist. And the reason why they still do exist, despite them terminating programs like TPS for some individuals and parole for others, both of which had legal status. Those populations may be out of status very soon. The reason why this relief is still in place to allow for protection against removal is because it is written in statute. And the only way to get rid of those protections is by repealing the law through Congress. So for now, immigration has to continue to process these kinds of cases that are there, green cards. And along with applying for green cards and certain types of relief, you're able to get your work permit as well as your social security number. That can offer you protection from detention, which ultimately can lead to deportation. So the time is now to make sure that you are exploring those options. One of the things that I want to let you know is that um, you at this time you may feel like there is no hope. But I can tell you, we are hopeful every single day in this office when we are seeing the results coming through, when we are seeing our cases being processed as usual, according to plan, as it has always been processed. That continues to let us know that this is available. And we do make sure that we work to the best of our ability to bring these results for our clients so that they are able to get protection. And one of the great things about these types of relief is that while you are going through them, you are able to hold your status in place. That means that you're unlikely to be, you do have a certain level of protection against detention. You are not on a list to be detained. And you will also have the ability in some cases to proceed with getting your work permit. And I know, for example, traveling is a major thing. And while I would say we're very conservative about our advice to travel, you are able to travel with a work permit across the country in place of a real ID. And in some cases, once you have the work permit and the social security number, you are able to get the real ID. Now, we help a lot of clients to get the T visa. And one of the benefits of the T visa is that while you're waiting, you get what's called a bona fide determination letter. And that clearly states that any proceedings that you're in, that means removal proceedings, are now put on hold and that you will not be placed in removal while your T visa is moving forward. And if you follow me, you will know that what the T visa is. You will learn what the T visa is. But that is, I would say this: if you've ever been in a situation where you felt forced to do anything against your will, and it doesn't mean they had to force you physically, say you would never have done what you did had it not been for the actions of the other person, this could possibly qualify you for the T visa because that is indicative of trafficking. So, for example, if you came to the US with a promise that the employer is going to get your work permit, they're going to get your green card, but they placed a condition on you that you had to come and work for them first, and you believe that this was legit, right? And in some cases, maybe you didn't know it was legit, right? But you came anyway because the employer convinced you that they are going to go ahead and get you the work permit legally. They're going to go ahead and get you your green card after you enter the US, or even if you've been here for a while. Then you find out later that they lied, and the only motive behind that lie was they wanted to get you to work for them. You would have never accepted the job if you did not know, if you knew that this job offer was fake, and the job offer with sponsorship, the promise of sponsorship, was fake. If you knew it was fake, you would never have accepted it. If that's the case, then you can qualify for the T visa. All right. So that's just one example. Another is, if you are here, I would say this, and this is where I depend on you to reach out to get the help you need. And we're here, the office is here to help, and we're making it so easy for people to get in touch with us. Our schedules are filling up very, very quickly. So here's what I say: make sure that you contact us or schedule your own appointment. If you click on the link in the profile, you'll be able to see the link tree. Go to the link tree. You'll now see a link there where you can confirm your own appointment. And we offer an evaluation form that is there for our purposes to determine whether you do qualify for one of the options we offer to be able to get you relief. But it's so important that you take the action now, because we are filling up. Um, okay, so no sound. All right, let's see. So I'm seeing no sound on Instagram. Let me know on YouTube. Let me know. Can you hear me on YouTube? Hi there on YouTube. Can someone in the comments just confirm whether you can hear me or not? Because it seems like on Instagram there's no volume. Um, I see somebody asking a question. Okay, so yeah, I can hear. Okay, okay, good, good, good. Okay, nice. Okay, I'm glad, because I've been having audio issues. Okay, thank you everybody for letting me know, confirming. Perfect, perfect. Okay, nice. All right, so we can proceed. So you can schedule your own appointment. Thank you, KK. You can schedule your own appointment. Go to the link in the profile. Go to the link in the description of the video and click on the link tree. At the top, you'll see schedule your own appointment, and then use our evaluation form. And the evaluation form, it serves as a substitute for our evaluation over the phone. So you can do this from the convenience of your home. Use the form to be able to determine whether there is something we can help you with. This is not a substitute for legal advice. We always say, even at the end of the form, if you still want to give us a call, call us and talk to us. But you can use the form as a starting point to say, okay, ST Law Office does have an option available. Let me proceed with a strategy session. And you can do that and just schedule everything and confirm everything there. So we've made it very convenient, but at the same time, we do have staff that is available 24/7 to answer calls. So you can always call. We are a safe space, and everything that happens is confidential. So you don't have to worry that we're going to share this information. It's one of the pillars, the fundamentals of being a lawyer here, that we must maintain your confidentiality. That's our job. So I told you about two types of protections against removal that can help you once while you're going through the process, and eventually it does lead to residence. That's VAWA and that's the T visa. And those are just two. There are multiple ways that we assist, but I'm giving you two right now based on the concern that we're all having about ICE ramping up detentions and raids. We are seeing increased activities. We are seeing increased, more strict policies that are meant to basically have immigrants' backs against the wall. And we want to find solutions for immigrants, right? And there are legal solutions. So make sure that you are taking action now. Don't sit it out, because you're just going to be more vulnerable. Okay. All right. So let me go ahead and answer questions. Thank you so much for joining. I am so happy to be with you again today. And let me see now. I've learned so much from you. Keep up the good work. Much love. Thank you so much. I appreciate that. That really touches me, and that's why I do what I do. I sent EAD renewal through pending VAWA. My current EAD card category is C09P, and I received receipt notice, but class category in it is C31. Does this mean they're working on my case or just wrong receipt? So the C31 is not going to be, that work permit will not be approved until your VAWA is approved. If you applied for an adjustment of status, you are supposed to apply for adjustment of status under the C09 category. If you're doing a renewal of that work permit under the adjustment of status. So if you do C31, it's just going to sit there, and it's going to sit there until your VAWA is approved. And in many cases, you already indicated on the, well, I'm not sure, I'm not your attorney. I can't give you personalized legal advice. This is general information. But usually on the I-360 is where we check the box that we want our clients to get the work permit upon approval under the C31 category. But that's not going to be issued. So I have seen work permits and renewals be denied based on wrong categories. So you want to follow up with your attorney if you have an attorney to make sure that you're doing everything right. Always defer to your attorney who knows your case best. You think it's possible to get a marriage-based green card with a dismissed petty theft and no case filed for possession of controlled substance? So here's the deal. You need to make sure you schedule a consultation, and we are actually consulting and working with clients who have cases like this, that they want to understand fully what needs to be done in their criminal case to either get the charges reduced, or what are the consequences and how can we mitigate those consequences, meaning, how can we reduce the harshness of the immigration consequences. For example, do we need a waiver, in order to get the inadmissibilities or consequences waived? But we need to talk to you, because when it comes on to controlled substances and criminal offenses, it gets very, very complicated. And the reason it's complicated is because when you're applying for immigration benefits, and you are found inadmissible based or you could potentially be found inadmissible based on a criminal offense, it comes down to the statute in the state. Remember, we have 50 states, right? And these different states have sometimes different state laws that apply. And so it comes down to what the immigration law says and what the statute says to determine whether the criminal offense is going to lead to a deportable offense, or is it going to lead to inadmissibility if you're outside of the country or you're seeking admission through adjustment of status. So we have to look at everything. So the starting point is going to definitely be talk to us, do that evaluation form. There is a section that asks if you would like legal advice based on any kind of criminal penalties that you're facing or offenses, and then we go from there. With that being said, here's my concern. Okay, you have a dismissed petty theft, dismissed as long as it's dismissed in a way that it's not going to be seen as a conviction. That's the best case scenario. However, we have, you said no case has been filed for possession of controlled substance. Sounds like you may have been arrested for that, but it sounds like they have not filed official charges, right? Maybe they found you with something. The thing about that is that under immigration law, there's also a provision that allows immigration officers to say, do they have a reason to believe that you were trafficking controlled substances? No, it doesn't say, was there a conviction? Was there an arrest? It doesn't say, is there absolute proof? It says, does the officer have a reason to believe? And that means that it gives the officer a lot of leeway in some cases to find you inadmissible and possibly permanently barred based on the reason to believe standard. There are ways that we can argue against that, but it really is on a case by case basis, and it really depends on the facts here. So this is where we need to talk to you. You know, as you can see, there's a lot going on there. And are you currently going through your immigrant your criminal case? If you are, it can our evaluation can also be helpful to a criminal defense attorney, because the criminal defense attorney can know how to approach your case. If the criminal defense attorney finds that it's going to be lead to devastating criminal consequences, the attorney can start to think of strategies and ways to be able to do a plea deal, for example, to get the charges reduced to something that may not have the same consequences. So get in touch with us, because this is there's no clear cut answer until we can actually review your case. Um, Hello. For those pending EAD applications, will the new rules of EAD being valid for 6 months now affect them? So I'm not sure. I would have to check to see what new rules you're referring to. But usually, if they do have any new rules about the employment authorization, it's going to have an effective date. So they're going to give a notice period. Um, is there any processing for work permits for asylum seekers as of now? Yes, they are still processing work permits for asylum seekers. Uh, can you go to biometrics with an expired passport? So, I believe they did reduce they weren't as strict with the passport. And I do believe at one point they did release guidance saying they would accept. However, I remember Trump 1.0, and I remember precisely when one of my clients didn't have, I believe my client didn't have a current passport. They had an expired one. They didn't have a current ID, and so we had to really jump through hoops to make sure that they got into the USCIS to do a simple biometrics appointment. So I can see something like that happening. If you have another form of identification with your government issued identification, bring that with you. But if you have nothing else, I'm not your attorney. I can't give you a particular legal advice, but if you have nothing else and you need to get to that appointment, it's possibly worth a shot to try to get in with that passport. But you should always defer to your attorney. Um, oh, thank you so much, Damien, and I thank you so much. All right. So now I'm on Instagram. Go ahead, put your questions in the comments. I'm going from platform to platform. So hold on, TikTok. I'm coming. We all can listen to these questions, though it may be questions that you have as well that you can learn from. So hang tight. I'm gonna answer. Me and my wife do interview almost 1 year now. Still, my I-130 don't get approved and my I-45 don't get approved. I don't know. I'm going to get another interview or no, maybe. Usually, if you've had your interview already and they haven't approved it, there may be something else they're looking into. So, based on my experience, usually this would sometimes they do suspect that maybe the marriage is not genuine, even if it is on your end, but they have their own suspicions based on the interview. They may be looking further into your background. Sometimes they're doing additional background checks that can cause delays. So, you should check in if you're beyond the processing times, then there are certain steps you can take. Want to give them a nudge to be able to either give a decision or tell you the status of the case. One is you can do a case inquiry, and the case inquiry would be able to tell that. Now the case inquiry, what they say is you check the processing time. So what we do is we go to uscis.gov. If you look at your case type on case processing times, you click on your case type and you see the range of time. So say it says 1 year to 4 years that is taking. Next to it, there's usually a button that says get case inquiry if the case is longer than 4 years. So if your case, and this is just an example, you need to look on uscis.gov to see what the processing times are. But if you, after you check that, you see that you're beyond the processing time, it's time to click on the button to do case inquiry. And then it's going to take you to a form to go ahead and submit your case inquiry. So that's one way. The other way is if there's an issue, you have an urgent issue, you can do. Well, actually, I'm going to tell you three ways. The case inquiry tool is if 120 days has passed and you got nothing, which clearly you're saying it's been 1 year, you can then call and say it's been over 120 days and you have not heard anything and you've had your interview. You can ask them for a status there. You can do a case inquiry. And then the other is you can request a case to be expedited, but you do have to show a reason for the expedited request. Like if you're having an urgent matter or a humanitarian matter, if there's a mistake that you've identified that USCIS has made, maybe they've overlooked your case and maybe that could be the mistake in itself, and you can give them a nudge that way. Or if there's going to be some kind of major financial loss, then you can use that as a premise to request an expedite. My fiance's mom is filing for him. She just got the email in January to send in documents. How much longer can he expect to wait before he gets the green card? Okay. It depends. If your fiance is 21 or older, it could be a while. And I don't know if 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 she got the email from the National Visa Center to start sending documents in, that means that no, you're definitely closer to an interview. I would say another 2 years, as long as you do everything correctly. I always say here, I encourage you to get an attorney, because if you don't get an attorney. Sometimes what happens is one mistake at the NVC leads to 6 months delay. And that can easily happen. It could be submitting the wrong document format. It could be submitting the document in the wrong color. It could be maybe you scanned the document and it truncated a bit, truncated part of the document. It could be as simple a mistake as that, and it turns into a 6 month delay. About 3 months for the NVC to get back to you to say, oh, please re upload your passport. It's not in an acceptable format. And then guess what? It takes another 3 months for them to then confirm it's good to go. So that's 6 months. Lord forbid there's another mistake. So you have to really understand how to navigate their system, what's required. The number one thing, and so take note of this because it's going to, just knowing this alone will help you in your case. Um, the number one thing I see that causes unnecessary delays and denials is incorrect income or inadequate income or um, incorrect submission completion of the affidavit of support. That's one of the avoidable simple problems that occurs, right? So make sure that you're on top of your affidavit of support, whether you're doing adjustment of status or you are doing your paperwork at the National Visa Center. We do help our clients navigate the consular processing, which means that your relative is outside of the United States, and so their process is going through the embassy with the help of the National Visa Center. We do represent clients all over the world in that process. So no matter where you are in the globe, we can help with that. Keep in mind, though, one of the most frustrating parts about consular processing, which is unavoidable, but I want to give you a warning, is the length of time you have to wait for the interview. So even after getting all your documents in, then you go into a wait period where you have to wait. So right now I'm seeing an average of a year and a half to even 2 years to process that. While you're outside of the US and filing the I-192 waiver along with the U visa, what's the wait time? So the U visa right now is very, very long. If you're outside of the United States, then their deferred action does not cover your, does not cover you during the process. If you're here in the US applying for the U visa, it means that you are able to get your work deferred action, which takes about 2 years, a year and a half to 2 years. And then you get your work permit, your social, you're able to live and work here while you wait for the U visa. Unfortunately, the U visa is taking up to 10 years, maybe even more. I have to check the National Visa Center, but it could be taking even longer. But at a minimum right now of 7 to 10 years to process that. So if you're outside of the US, you're looking at that wait time. And they will consider the I-192 at the time of this decision. Me and my wife do interview almost 1 year. So I answered that. Um, okay, good, good, good. I see. Do you think that pending asylum to get interview? Yes, pending asylums are getting interviews. So make sure you're preparing for your interview. How do you get protection from removal? So I started with this topic, and there are multiple ways. I couldn't possibly cover those ways. But what we do is we do an initial evaluation to see if one of the ways is able to apply to you in particular. It's not legal advice, but it's a start for you to understand what we could possibly offer you, and then it's for us to understand what we can do for you. So you can start with so we do offer an online form that can help you with this. And then once you do pass that part of the form, it means that there's possibly something we can offer in our services, and at that point we want to do an appointment to talk about strategy moving forward, confirming you qualify by getting legal advice in that strategy session, and then moving forward with a strategy. Because I talked about two, right? So the two, VAWA and the C visa, these are types of relief that are available even if you're here and you don't have your papers, even if you overstayed your visa, even if now you are looking at a situation where you're going to lose your status. For example, we do have people who are losing their TPS, Venezuelans are losing their TPS, which means that we're going to have about 350,000 people who were here legally that are suddenly not going to have their papers. But here's the deal, they're not going to have their papers, but at the same time, they can't go back to their country because it is not stable enough. So these are alternative options that can be available to help, help offer protection. But we need to talk to you to figure out if one of these ways can work. But here's another thing I want you to know. Now, it's a scary time, and nobody wants to be accosted by agents, people in plain clothes, people who are walking around with masks. That is pretty scary, and that is happening. People are being disappeared on the streets by ICE agents, but these ICE agents are appearing in a way that is scary. Some people can understandably believe that they're being kidnapped, right? They're being assaulted by somebody that's going to hurt them, that they're not ICE agents. So it's a scary time, right? So this is where I say it's best to make sure that you can evaluate your options and know your rights before that happens, because the risk is high, and I would say, nobody's safe. We're seeing US citizens facing this. On a construction site, it was all over the news. A US citizen was assaulted. He was yelling, he is a US citizen. He presented his ID, and it was a real ID, and they disregarded it and told him it was fake and detained him anyway. So it's what I'm doing is telling you this to let you know that I could be driving down the road, and just based on the way I look, just based on my accent, I could be possibly detained, even though I'm a US citizen, even though I was born here. That can happen to me just by the way I look. So we are not safe, right? Nobody is really safe. But what I would say is that it's important to know that if you are in this situation, you have rights, you have recourse, and we have helped clients to get out of the situation even when they've been in that situation. So I don't want you to believe that if you are detained, it's the end of the world. We do have solutions in immigration court to help to get you out of detention, possibly through bond. And sometimes ICE themselves can determine that they will release you on their own judgment. So, and keep in mind that in immigration court, we can also bring additional relief to stop your removal. It's also important to know that what is happening now is that if you have been in this country for less than 2 years, even if you're going through the court process, they are now they are now saying, since you've been in the country for less than 2 years, they can remove you expeditiously, no court hearing, put you on a plane and send you out. At that point, if you are afraid to go back to your country, you know you cannot go back to your country because you will be face certain harms, you will be persecuted, you'll be harmed. At that point, it is very important that you state that you need a credible, fair interview. That credible, fair interview, they have to do the credible, fair interview to be able to determine whether you should, and in that case, sometimes it goes before a judge, where you can then go through the regular process and not expedited removal. At that point, it's very important to get a lawyer. If you don't have the number of a lawyer, make sure you have one now, in case you need to make that quick call. So, if you are ever detained, the first thing you do is exercise your right to remain silent. I know that's hard to hear. I know that's hard to stomach, but it has helped. It has helped my clients because it allows me to talk to my client first, to understand what's happening, and for us to be able to collaborate on their relief, on an application for bond, or on their relief, right? But if ICE at that point, the police, they're not your friend. Unfortunately, even the police, when they're in this immigration setting, they're not your friends. So it's not the time to just start talking and answering questions. Make sure you say calmly and politely, as much as you can, that you would like to exercise your right to remain silent and you need to contact your lawyer. You're not going to answer questions, you're not going to sign any documents until you talk to your lawyer. That's the first thing. It's yes, the point of that is not to get you out of the detention. The point of that is to allow you to not say anything, because you do have the right not to incriminate yourself. If you start saying where you're from, when you came, what, anything regarding your status, immigration status, they can use that information against you to get you out, to even put you under expedited removal. So it's very important that you look out for your rights. Okay. And there are legal solutions, even in the case that you do find yourself in trouble. So keep that in mind. There are relief. We can go before the court and we can ask for relief that they could possibly cancel the removal, and you could even walk away with a path to a green card. But you have to make sure that it's a very strategic process. It's nerve-wracking. It's sometimes even not as fast as we'd like, but it can be done. All right. So that's my piece here. So the message here is you can avoid removal altogether by figuring out your options. But at the same time, if you ever find yourself in trouble, there is legal relief. So keep that in mind. And it's important to know that too. All right, let's see. Okay, I'm going on TikTok now. I know TikTok, yeah, there are a ton of questions. So I'm going to start here. Should I file again or the waiver is still pending? So I'm not sure. Can you mess up some questions on green card interview and still get approved? That's a good question. I would say it depends. It's possible. It depends on the kind of questions you mess up on, though. Is it feasible that any couple could mess up on a question like that? Usually, they answer these questions. They ask these questions strategically, though. The purpose of their questions is not to give you wiggle room to answer, answer in a way that doesn't match. They are doing it as a way to see, do the two of you say the same thing, right? So they're not going to ask you anything that's going to be open ended. They're going to ask you something that there's definitely going to be the same answer for the both of you. They do take these questions very seriously. And I have seen them send notices of intent to deny based on, inconsistent answers between the spouses. So while it's the interview, the purpose of the interview is not to be perfect. You do have to make sure that the both of you are on the same page. What you can do is, if you go to Linktree, you go to the link in my profile, you will see, if you scroll to the bottom of the Linktree, one of the options is, I believe, say yes to the green card, to marriage based green card. And there I do provide sample interview questions that you can possibly use. Now, keep in mind, it is not a substitute for legal advice or representation. And it doesn't mean I'm your attorney, but I put it out there so that it can help couples to possibly look at sample questions and see what that the questions look like, what they need to prepare for. They usually, when they ask these questions, it's based on your routine and personal information. So they're going to ask you questions about the bedroom. What is the color of your sheet? What is your where is your living room? Which side of the bed do you sleep on? Who gets up first? Who makes breakfast? What's your favorite color, right? And they are going to ask those kinds of questions. How did you meet, right? When did you get engaged? How did you get engaged? So it's very important to, be prepared. And I do offer a sample to those questions. And I also offer another handout if you're preparing to file a marriage based green card. I offer a handout that talks about a winning green card process, how to prepare a winning green card application. But nothing will ever substitute having your attorney. If you file an I-601 waiver, then request it to be expedited, and they deny the expedited request. If you have any new evidence, you can always ask again. What if you don't have a lawyer at the time? You are able to get one, right? So make sure, here's the deal. This is why I say plan ahead. Find out what you qualify for to avoid situations where you're detained. But if you are detained, plan ahead, right? For that possibility, if you're at risk, if you're at a higher risk, have an emergency contact, have your important documents in one place. Make sure your emergency contact knows where those documents are. Make sure your emergency contact has a list of lawyers that they can call. Have an emergency fund available in case you need to pay a lawyer, because many of them do charge. And make sure that you can have those lined up and instructions lined up for that emergency contact, so that you may not you may not have a lot of flexibility to sit down and call lawyers. They do give you a list of low cost lawyers, but I have not heard great things about that list. You can always try, but make sure that you do have a choice, right, beforehand, by planning ahead. Make sure all of that is lined up, and you have that conversation with your emergency contact, or that person who's close to your spouse, your relative, your friend. Make sure you have those conversations. Also, make sure that you do have money available in case you need to do bond, because there is a cost for bond. The cost for the bond is it can range from 1,500 as a minimum, but I have seen it go as high as 8,000. So make sure you do have a plan on bond as well. What kind of lawyer help get someone out of ICE? So it's going to be a removal defense lawyer, and we do offer removal defense here. Said we need to find a lawyer to help get him out. A certain kind of immigration lawyer, removal defense, and you can always give us a call and talk to us about the situation, and we can see if we can assist. At the first interview, officer told wife that her visitor visa is revoked. Can that affect second interview? So give us a call. I don't know why the officer at the interview, I don't know if this if it was a visa interview or adjustment of status interview. If the visa was revoked, then the reason for the revocation is going to be very important, and that's going to determine whether she can get a visa in the second interview. How can we be protected when one has VAWA? VAWA offers you deferred action. It's a type of protection where they don't deport you. You get a 2-year work permit, and once that means you're approved for VAWA, you do get to apply for your green card at the same time. What time is the best time to call? You can call anytime, 24/7. If you we a majority we have 24/7 staff, but between 8 a.m. and 5 p.m. is when we're busiest, when we have most of our staff on hand to answer calls. How long does T visa take? We're seeing a year and a half to 2 years now. I know, yes, I'm up to 2 years. I filed VAWA May 2023 and got three prima facies. How long? So I would say about 3 years now. And you can always check case processing times on the USCIS website as well. Mm. How long it take to get approval when you submit I-130 for your wife if you are a green card holder? So I would say 9 to 12 months. And then keep in mind that your spouse, if they're in the US, should not be overstaying their visa because it's going to take away their chances to apply for adjustment of status. Definitely give us a call if you have any doubts about that. You probably need help if you don't know what I'm talking about. Hi there, Karen. It's nice to see you. If you file VAWA 2022 and the processing time was 36 months, but it changed to 41, will I have to wait that new processing time? No, not necessarily. It means that the longest case is 41.2 now. So it doesn't mean yours could still be, 3 years. I would say it's more around the 3 years for most people, but they do the shortest and the longest range of time. U.S. citizen parents sponsor adult unmarried children. Priority date 2018 case NVC. How long again for green card interviews? I'd say a year and a half to 2 years if once you are documentarily qualified by the NVC. It's been 3 months since I applied for I-765, category C9 concurrently, NBC field office, still no decision yet. Is it because they want to schedule an interview? No RFE for any, not necessarily. It can be 3 to 6 months. So don't panic yet. It's nothing out of the ordinary. But if you do have doubts, always make sure you get the advice of your lawyer. All right. If I overstay and apply for EB2 NIW, can I get a waiver? Unfortunately, not. That's not going to help you to get adjustment of status. When you're applying for adjustment of status under the national interest waiver, before you file your your priority date has to be current, and you have to make sure you do not overstay before applying. I mean, after you file the adjustment of status, that's okay, but before, you must not overstay your time. So that is where they can get you, right? You can file the petition, it can get approved, yay, but if you do not meet the current priority date and you file your application before you overstay, they can then say, great, you have an approved petition, but you have to go back to your country to do the interview. The catch there is you've already overstayed, and when you leave the country, now you may be barred. If you stayed for more than 180 days, you could be barred. If you're under 180 days, not necessarily. But over 180 days, then you're barred for 3 years. So get legal advice for sure. Don't sit on it. Don't wander. Now is not the time to wander, guess, hope. I mean, we can hope, but hope is the beginning, right? Hope is supposed to lead you to action. We can't just sit here and hope alone. We have to take action, and we have to take action based on faith in some cases. So Thank you so much, Damien, for the compliment. I appreciate it. Um, I feel I filed VAWA May, so I answered that. All right. Okay, so I'm gonna come back to USCIS is scheduling interviews quickly after filing. Is it because these cases are simpler than others? So what they have done is they have a process where they start with the new and work up to the old. So we could still be seeing that policy in place. How can I get your address to come to your office? So we do our consultations because we represent clients nationwide. So we don't do in-office consultations. We do consultations via phone and Zoom video. So what you can do is you can use our online form to do the initial evaluation, or you can call us and they will definitely, staff will do the initial evaluation and get you scheduled. Get started now because we are filling up very quickly. Is there a number I can call for information? Is there any chance to change of status for those who are overstayed visa with a child who has a disability? Give us a call, because even though the change of it may be possible, but you've already overstayed. There are policies in place that could possibly help you to still get an extension and get forgiven on the overstay, but we need to understand how long the overstay occurred, what's the seriousness of the disability, and then we can look at certain forms of relief. Like we have gotten our clients what's called deferred action in the case that they're facing a serious health issue that they cannot, where they cannot seek any treatment in their own country. And that's just temporary relief and protection from removal. So that could possibly be an option, but we need to talk to you to figure out the facts here. I'm so sorry. So your child's father tried to unalive you and they locked him up and deported him. So I file asylum here waiting on my interview. Should I have a lawyer or do it myself? Give us a call because I would need to understand what is going on here, what happened, what's the status of the father of your child, because asylum may not be the only form of relief. How long ago did they deport him? If, for example, if he's a US, if he was a permanent resident, he was deported, and you're the spouse, you were the spouse. I know you said child's father, but that could possibly lead to VAWA if you're not married. But in the midst of right before he tried to do that to you, he did other things to you. We need to find out those facts because you may qualify for the U visa. You may qualify, and yeah, the U visa is very likely here, depending on what's going on with the criminal offense, and also T visa if he forced you to do things that you were not willing to do. Give us a call. Let's talk. It's important. Asylum may not be the only form of relief here for you. Should you have a lawyer for the asylum interview? I would say yes. I would. You're never gonna catch me say don't have a lawyer. So I'm here more than 5 years, and I have a baby here for an undocumented person. Okay, so I'm getting more context here. So give us a call. There may be relief here. We need to talk to you, and it's urgent. I would say it's urgent at this point. You want to talk to us, so give us a call and start with the in. Give us a call or start with the initial evaluation form online, and then we can schedule. You can schedule yourself, help yourself, and schedule yourself, or you can give us a call and we'll get you on the schedule. I filed I-130 and I'm in the US waiting in list. I came in 2005 with my family. All my family are residents, permanent residents. I could be deported if some police stop if I'm walking outside. It's possible I have to talk to you about the facts, but an I-130 alone is not foolproof protection against removal. It's not. It may help you in court, but we have to understand the facts here. And since you've already possibly overstayed, that is another hurdle. Thank you so much, Dream Queen of Hearts. Um, What if F1 student marries a US citizen? After months of marriage, he lost his F1 status. He is legal in the US with marriage green card process. Can he go outside the country with green card process? If he has a travel document, it's possible. But if he has no travel document and he's going through the green card process, he should not be traveling. Furthermore, I'm very conservative about travel right now. Um, I would say I am not recommending travel. Stick it out and see your process through first. But let's talk. I don't know your facts, and that's where it's important. Is there a number I can call for information? Yes, look at the bottom of the screen. You'll see the number at the bottom of the screen. Call that number and you'll be able to talk to staff. They'll do an initial evaluation and get you scheduled should you pass that initial evaluation. The reason we do the initial evaluation is because we don't want to waste your time and money. We want to make sure that you are you do qualify for the services that we offer, and then we can move forward with that strategy session. So go ahead and start there. Give us a call and we can help you. Is there any chance of change of status for those who overstayed visa? So I answered that. All right. That's going to be it for me today. I am going to work to be back tomorrow. Make sure you go to the link in the profile, go to the link in the description of the video. Go ahead and schedule time, do the initial evaluation. You can go to our website. If you don't want to do the online initial evaluation, go and just fill out the form. It's confidential and we'll give you a call. We will contact you and then we can go from there. But I would say the best thing you can do now is take action. In the meantime, make sure you like, subscribe, hit the notification bell, follow, because this is how other people are going to see information that can empower them through their immigration journey. So make sure that you're doing that. And then also, if you're new here, you don't follow me, make sure that you do that. Take those actions because you can see when I come on. And if you're free, you can come on and you can ask your questions. Thank you so much, everybody, for your time today. All great questions as usual. And let's move forward with faith, with hope, taking action, and focusing on solutions. That's the key here. There are solutions, and that's what we're helping. That's what makes me wake up every morning, right? With all the news, all the terrible news, and all the chaos that's happening. What gives me the inspiration are my clients, and also knowing that there are legal solutions out there. Have a good one, everybody. Take care. Until next time.